SJC-11684, Commonwealth versus Cassino.
Good morning, Mr. Safar. Just
Morning, Your Honor.
wait until we set your timer, and then you can start. All right.
May it please the Court, Aziz Safar on behalf of Adam Cassino. This is the defendant's appeal from a conviction of murder in the first degree on theories of deliberate premeditation and extreme atrocity and cruelty. The appeal centers on the motion judge's refusal to suppress evidence resulting from a warrantless search and seizure of the defendant's sneakers at the Massachusetts Alcohol and Substance Abuse Center. The defendant was civilly committed where the admission process necessarily required him to tender his sneakers to the facility during his stay.
Policy, you don't challenge the policy.
No, we're not changing.
Policy considers the clothing items and so forth as basically contraband, right?
Contraband, but contraband in a stored area, not contraband. This wasn't contraband that he had brought in to the prison. What it basically, under the department regulations, a civilly committed person is strip searched and his footwear and clothing are taken into a storage area until the commitment completes the term of his treatment. But what happened here was after they interviewed the defendant, the homicide detectives asked the correction officer in charge to see the defendant's clothing that he had been admitted into the MASAC with. And so he takes them to another building. He retrieves the clothing and the sneakers from a bin and then from opaque paper bags, and he shows the items to them. And then the detectives...
Don't seize them. They get a warrant before they take them, right?
I'm sorry, Your Honor?
They get a warrant before they take the items from the MASAC.
Well,
right?
That's not, well, no, not exactly, because our position is that there was a search and there was a seizure because there was an interference. The position...
By asking to look at the clothing, that was a seizure?
Well, they're holding the items for the defendant. And
you're saying he has a subjective expectation of privacy in those items? I don't understand that.
Yeah, well, I mean, I know my brother cites to the Silva case, and this defendant was in a better position than the defendant in Silva, in that this defendant was a civil commitment.
It was not voluntarily there as a hospital patient.
I'm sorry, Your Honor?
I mean, you know, to try to compare this to a hospital patient, as I think you're going to, is not really right either, because he's not there voluntarily. It's a Section 35 commitment. It may be civil, but it's a commitment.
He's not there. He's not there voluntarily. However, we're arguing a bailment situation because he tenders these items with the expectation that they would be returned to him. So he has this continuing ownership interest in the items that he doesn't.
Wouldn't that be true for a prisoner too?
Not necessarily. I mean, in the Silva case, that defendant's sneakers were considered contraband.
Well, but in the same way, I mean, when he left, when Mr. Silva left the House of Correction or the jail, I guess it was a jail, presumably his sneakers were going to be, I mean, he may end up going somewhere else, but if he just left the jail, his sneakers would be returned to him.
I don't think that was a situation over there. I think they were deemed contraband to the point where they could be disposed of. I don't think that's a situation whereas in this case there was an expectation that these sneakers, his clothing, would be returned to him. He was a short-term commitment. It was 30 days. And this wasn't a situation where the person's there for 2 or 3 years, he doesn't get access to them, and then there's much more control and interference by the facility over the items. This was, he's here short-term, he'll be released, and these items will be returned to him, and he's acting on that expectation. The other problem in this case is what happened here didn't bear on any of the facility's legitimate hygiene or security protocols.
You don't think having people that come into, do you say it MASAC or MASAC? Mesa.
I guess Massac or Masac.
Well, in any event, you don't think that having people come in and then taking their clothes to I think you said they wash them, and then give them, it has a whole
That's
lot to
fine.
do with the facility.
That-
They could
that
be
has to do with
carrying
the-
stuff
that has
in
to
their
do with
clothes?
That has to do with the facility, but what I'm talking about is this interaction with law enforcement. When you inject this element of law enforcement, and they're acting at the behest of the detectives, going into this secure area where only the superintendent, the deputy superintendent, and the property sergeant, it was closed off to everybody else. It's a secure area. And they're acting under their directive and extracting these belongings that are there in connection with this civil commitment. Now they're becoming agents of law enforcement. And I would say under those circumstances, I don't think we can impute to the defendant this understanding that he relinquished his expectation that they wouldn't be turned over to law enforcement, because he had no idea that the Massac would do something like
Weren't
this.
turned over, they were just shown.
Well, I would say that little bit of interference was enough. I mean,
Now, in the situation in a prison, are you saying the same thing?
if the property was not considered contraband that was permanently taken away from the detainee, or
It was stored in a safe locker, because everything that comes in with the detainee is taken away and stored in the
but bring that
safe
to our
locker.
case, though. He has an expectation that I'm leaving in 3 weeks, and these are coming back to me.
And the
And there's-
prisoner may well also have that same expectation, because they just think it's my wallet, it's my,
Pre-trial, especially.
yeah, I'm going to get everything back. Same expectation.
Well, then perhaps it would be the same, because again,
Can't even show it to police.
not at their directive, because at that point they're acting as agents of law enforcement. It's not something that's serving. They're not conducting something that's related to the administrative functions of the institution. This is strictly, they become a conduit for the detectives at that point.
So-
And
And if I can move you to the second point, which I think Mr. Hillman argues, that even if you delete the part of the search warrant affidavit of any mention of the sneakers with the red-brown stain on it, you still have probable cause. And what do you say to that?
well, I answer that in my reply brief. First of all, I think under Article 14, there's a stricter application of probable cause. And the second part is that we believe that this would, applying the independent source rule to something like this, would violate Article 14, because the affidavit is so linked to this unjustifiable, unreasonable, warrantless search. It was a blatant effort by law enforcement in conjunction with the prison officials, or the Massac officials, for the sole purpose of extracting evidence of a crime, and you can't do that. So
Don't you think
it's so tied in, and there's also the concern that it would encourage a non-compliant officer to conduct a warrantless search and then try to bolster a subsequent warrant application with the items
But
of the legal search.
that's the point of excising that information, is to see what you've got left.
But I think it would be bad policy, because what it's doing is you're having a situation where officers now can say, okay, we might not have probable cause, but we have these other facts that we can lean on later on, and our rogue conduct will be upheld, because
But
we have.
they got the search warrant right away. So what do you mean?
You're bound by the affidavit, whatever they say in
And
the
the
affidavit.
affidavits had, in addition, the defendant had stolen prescription narcotics from the victim on several occasions. The defendant had, shortly before the victim's
But
death,
but the
stolen prescription narcotics from a neighbor. 90 pills of prescription narcotics were missing from the victim's home. The victim's death was sufficiently bloody that the perpetrator's clothes likely contained trace evidence of the victim's blood. Why isn't all of that enough for probable cause? And it was done before they actually seized the sneakers.
Because it relies on the tainted evidence. I mean,
How?
it's intertwined it's built on, I mean, I think if we were to allow this type of thing, I mean, we'd always have to second guess magistrates. I mean, which part was allowed? I mean, this evidence, I mean, they gained the advantage of bolstering this affidavit with the sneakers, tying in this. I mean, remember, the purpose of the warrant was to secure the sneakers.
The only thing that they gained by looking at the sneakers was that they were reddish-brown stains.
Right, and
They
that was,
could have been dirt.
well, under the trained eyes of the homicide detectives, that's not what they thought it was. They immediately suspected it was the victim's blood in the context of the case. And this was information. Sergeant Fontaine at the suppression hearing testified that he's not an expert on it. He saw something on the sneakers. So the MASAC had no idea that there was anything going on with the sneakers. So this evidence in the affidavit was tainted. And I'm not so sure you can excise it on these facts where they made a blatant effort, a purposeful and deliberate effort for the sole purpose of acquiring evidence of a crime. And they used this institution to do that. I mean, they weren't doing anything that furthered some policy concern of the institution.
Would it matter if DOC said before they left, why don't you come over and take a look at his property? I want to show you his property, which is at least what Mr. Hillman claims is what the evidence showed?
Probably,
as opposed to the police saying, I want to see his property?
probably for Fourth Amendment federal jurisprudence, because I think if the institution initiates the search, that would make a difference, and it'd probably be upheld under those circumstances, but I don't think we have to follow that under Article 14. And the motion judge, anyway, that's not what the motion judge found. He found that it was at the request of the homicide detectives. So I don't think that applies in our case either way, unnecessarily.
So your view is that showing is equivalent to a seizure, that there's no difference between saying, I'm going to take these clothes out and let you look at them versus taking them to the
I mean,
police
you
station
could go all the way
lab.
back to cases like Jacobson. I mean, any interference with a possessory right can constitute a seizure, however slight. And this was, remember, this was, we're arguing in the brief that this was an involuntary bailment situation. And the encroachment was right onto that situation. He had no reason to believe that this property would be shown to the homicide detectives. He's there for medical treatment. Perhaps not a hospital, but it's more analogous to a hospital than a convicted felon situation or even a pretrial detainee. Are there any more questions on this issue? Or did you want me to go on to the, I'll turn to the juror bias issue. Juror 110 told the judge that she had never spoken with Juror 16, and this was during the voir dire. But Juror 16 referred to her by her name and informed the judge that they did in fact speak during the break.
What about Trevon Martin, not about this?
I'm sorry, Your Honor.
What about Trevon Martin?
Oh, right. Well, the Commonwealth is arguing that this was all in the context of talking about another case. But I think the important point here is, was her integrity in question at that time? When she tells the judge, no, I never spoke with Juror 16, and Juror 16 says, we did in fact speak, we spoke outside. Now, whether they spoke about this case or not, I mean, her integrity is in question at this point because she's blatantly lying. So much, she wanted to stay on this jury, so much so that she's telling the judge she never had this conversation. And this was in the context of her being overheard saying, he's probably guilty already.
And Juror 110 said that was about Trevon Martin.
Juror 16 said they were talking about the Trevon Martin case. Juror 110 said they didn't talk at all.
Sorry, I'm getting the numbers.
No, that's okay, yeah. The juror who was candid about having the discussion during the break said, we talked about the Trevon Martin case. We did not talk about this case. Juror 110 says, no, I don't know any of the jurors. I don't even know the man in the beige shorts, and I didn't talk to him. She didn't say, I didn't speak with anybody about this case, or I didn't speak to anybody in the context of talking about this case. She said, I didn't speak with anybody, period. And the point is that when she's blatantly lying like this, she's put her integrity in question, and you don't know whether her answers to the judge are truthful at that point, and she should have been excused. The judge found, well, maybe there's an inconsistency here because she's saying, I don't find the witnesses credible, and at the same time she's saying that he's probably guilty already. But given this culture, that culture where a lot of the witnesses who testified at that point had impaired memory, I think it's not necessarily an oxymoron to say, okay, I can't rely on what these witnesses just said, but he's probably guilty for other reasons, and she should have been excused.
Now, on the Matai issue, or Matai, that Mr. Hillman raises as a 33 issue, how do you claim that that's a miscarriage of justice to have that happen?
Well, first of all, the trial attorney didn't concede that it was the victim's blood on the shoes. This was during his examination of Detective McLaughlin. He poses a hypothetical question, and it was, quote, if there's the victim's blood, unquote, and then goes on to ask him, would you stop looking for the shoes? And then there's another point during his examination where the detective goes into a narrative and references that the blood on the sneakers was the victim's blood, and he just says, mm-hmm. So it's not necessarily that the point is conceded. And as far as this idea that the jury should be presumed to be able to fill in the blanks, this court in that same case said that they can't be presumed to do it. They'd be acting as their own experts if they were to do that.
But in Matai, I forget, I don't recall, I think there was a view that the numbers were going to be quite small, or that, but here they're extraordinary. I mean, 1 in quintillion. What's the theory? That counsel was ineffective for not objecting?
Well,
to
the
them?
evidence was the DNA evidence that did contain the statistics. I would suggest that the jury should not be able to draw an inference that the numbers were substantially the same, so that they could come to the conclusion.
I take that point, but I'm just playing it out at trial. So at trial, they offer this DNA evidence from the sneaker, and nobody asked the question, and what is the probability that that's a random result? Is it your view that defense counsel should have said, Your Honor, I move to strike that testimony because they did not provide that statistic, which is required by Matai?
I would object. I object that the Commonwealth hasn't laid the proper foundation to establish this as being the victim's blood taken from the tongue and taken.
And if that had happened, the judge should have said, You're right, I've read Matai, sustained, and then the Commonwealth could say, Oops, I forgot to ask the critical question, and then that would come in, wouldn't it?
If it played
And it would
out
be
that
worse.
way,
It would be worse for the defendant because now you'd have the 1 in quintillion coming in, when before you didn't have that. So I'm trying to figure out. I mean, I understand the point, but I'm trying to figure out whether counsel was ineffective in not objecting to it because the objection would have triggered something worse.
It could have. Also recall that the theory of defense was third-party culprit. I mean, it could have played out in that scenario, but it's their burden, and it was something that they left out, and it left the jury wondering, and that's where we're at now.
Yeah, but if it's ineffective assistance, you've got to. The second half of that is, well, would it have made a difference to the jury if this is under 33E or under Safarian? Would it have made would the counsel have achieved something material for the defense? And in this case, it seems as though those statistics would only hurt, and they would only strengthen the Commonwealth's case that this really was the blood of the victim.
Well, the statistics. The statistics that were missing, like I said, were different than what was taken from the butt of the bat and the barrel of the bat. And the...
They worse or better for the defendant?
No. Well, I guess they would...
I thought the statistics came in with respect to the bat.
They did,
They did.
Right.
Yeah, the statistics came in with respect to the bat.
and to the cigarette.
Yeah, right, and there was the handler DNA, there were the mixed profiles, the handler DNA, but I guess to answer your question, I'm not certain how that actually would have played out, if it would have been better or worse. I would ask the court to look at the totality of the record and to see that the evidence that they had left out left the jury wondering as to what the significance of these statistics mean, especially in light of the third-party culprit defense, where the bat had mixed profiles. It also included Tommy Kinsilla's DNA. He wasn't ruled out, although the defendant was the dominant. He had more alleles showing on more locations, where the sneakers didn't have Kinsilla's DNA at all. So, and that, I guess that's my best answer for that.
Thank you.
Thank you.
Before you start, Mr. Hillman, I wish to commend you for bringing the Matai issue to our attention.
Thank you, Your Honor.
It likely would have been spotted by the judge under 33E, but you're acting in the highest tradition of the prosecutive trade, so we appreciate your doing that.
Thank you, Your Honor.
And pass that back to his boss, okay? Okay, now it won't, and now we're going to start to grill you, so, but please proceed.
Thank you. May it please the court, Zach Hillman on behalf of the Commonwealth. With me today is ADA Ian Pollenbaum, who is the trial prosecutor in this case. We're asking the court to affirm the defendant's conviction. I'll begin with the motion to suppress issue unless the court prefers me to start elsewhere. And Judge Healy properly determined in this case the defendant failed to meet his burden of showing that he had an expectation of privacy in the complaint of intrusion here, which was the showing, mass act showing of the sneakers to the Boston Police Department detectives after they had interviewed the defendant.
You know, let me just ask you this, though.
Yes.
Is this, is it just the showing you're concentrating on, as opposed to actually taking them away?
Yes, Your Honor.
Okay, so let's say it wasn't shoes, but the police, because there's a bunch of cases in this area that fit into this scenario, where the police come to the jail, I mean, it's often a jail, and say, Mr. Correctional Officer, I'd like you to go in there because there's some papers there that I am interested in what they say. And so the correctional officer goes in there and looks at them and then tells, nobody takes them out yet, but tells the police what's on there, and then that gets used for a search warrant. What's different?
I think that what's different in this case is that what the police did was no more intrusive than what the Mass Act officials did when they initially seized the sneakers. And that is, they took the sneakers pursuant to their valid institutional policy of deeming the sneakers contraband. They had to examine the sneakers in order to fill out the inventory sheet, and then they put them into the bag. Here, when they took the police officers to see the sneakers, they merely took the sneakers out of the bag, placed them on the table, and as Sergeant Fontaine testified, the officers merely viewed the sneakers. So what they did was no more intrusive than what the Mass Act officials had done initially.
How about my piece of paper? I mean, that has stuff on it.
That may be a different question, Your Honor, based on a different set of facts. I'm not arguing here for a broad rule. What I'm saying is, in this case, I think what distinguishes this case from Your Honor's hypothetical is, again, the fact that what the Mass Act officials did was nothing more than, what BPD did was nothing more than what the Mass Act officials had done initially when they seized the sneakers.
So another example, and I think probably this is an easier one, if the police had gone in and wanted to essentially search the clothing that had been and check the pockets to see if there was anything in there different?
I think that maybe a different situation. There, arguably, the police went a little bit further than what the officials had done when they initially seized the clothing. Now, if there was testimony that during the initial seizure of the clothing by the jail officials, they went through all of the pockets, and again, the police were doing no more than what the jail officials had done initially, that might be a situation where the defendant's expectation.
Well, except, doesn't the purpose matter? In other words, if the Massac officials search the clothes or do the same thing, they search the clothes because they're trying to make sure that if the person's going to keep his clothes, that there aren't prescription or there aren't there isn't stuff in the pockets that he's going to be able to use and overdose or whatever else. The police have a different purpose, and it seems to me the police, Massac's institutional and health reasons for doing what they're doing matter in terms of the validity of the search. And if the police are coming in for criminal investigation purposes, that's a different. It matters that they're the police and the other people have a different purpose.
It very well could, Your Honor. I'm not arguing that it doesn't. Again, what I'm saying is I'm not arguing for a broad-based rule here. What I'm saying is, in this case, what the Boston police did was no more of an intrusion than what Massac had done initially. And
Did they need a warrant?
I don't think they needed a warrant because the defendant didn't meet his burden of establishing. Well, let me back up.
Need a warrant to take them? Did they need a warrant to take them?
We suggested to the motion judge that they may not have, but
No,
ultimately
they got one,
did.
but I'm just asking, how far this goes, because it's sort of like the second touching.
Well, I would say this, where the Boston police observed in plain view right on the sneakers where they were put on the table, the RBS, that may provide them with probable cause to take the sneakers.
I'm sorry, the RBS?
I'm sorry, the reddish-brown stain, the red stain. I apologize, Your Honor. That may provide them with probable cause, but certainly we always expect that the best course, I should say, is to get a warrant, and that's what the Boston police did here.
I guess the question is, if there's no reasonable expectation of privacy?
Well, what I'm saying is he hasn't established any expectation of privacy that Massac would allow the Boston police to do what Massac officials had already done. That's what I'm saying. I'm not saying that there is no expectation of privacy that the Boston police would, having no basis to just take the sneakers. That's not what I'm suggesting. Of course, getting a warrant is always the best course of action. That's what the Boston police did here after their very reasonable, they took the very reasonable step they took the very minimally intrusive step of going back to see the sneakers, as I would argue, at the invitation of the Sergeant Fontaine of the Massac institution.
If you can go back to that, I mean, was the judge clearly erroneous in his finding?
I think so. I'll say this. Sergeant Fontaine testified very clearly that it was at his invitation that the Boston police went back to view the clothing.
And he's from DOC.
He's from DOC.
But he has a right as a person from Massac to do whatever he does with the clothing related to his own institution, or the defendant in his capacity as a Section 35 committee. Mm-hmm. He doesn't have a right to act as the agent of the police in a criminal investigation. So the fact that he invites, I'm not sure makes any difference here, unless the purpose is for something to do with Massac or the defendant's health.
Ultimately, I agree with Your Honor. I think it makes no difference whether Boston police asked or whether Sergeant Fontaine asked. Again, what matters is that what the police saw, what the police did, was no more intrusive than what Massac officials had done initially, and the defendant didn't have an expectation of privacy. He didn't show that he had an expectation of privacy in what the initial steps that Massac took when they inventoried his sneakers, considered them contraband pursuant to their valid institutional policy of doing so.
Does the policy use the word contraband?
It does, Your Honor. At page 9 of the Commonwealth's
and
appendix.
Did they show that? I didn't get this far. Did they show that to the person who's coming in?
There's no evidence of that, but I would argue that he plainly was on notice that his sneakers were going to be considered contraband because they were taken from him, and he was not allowed access to them until he was released.
Was he aware when the police sought a search warrant that his sneakers were being taken?
There's no evidence in the record as to that. he didn't show that when he was confronted with the fact that they had taken his sneakers, he objected to it.
And when was that?
That was
When he was confronted?
on September 8th, I believe.
But wouldn't they have had to serve the search warrant on him when they took him?
I don't know if it was served on him or if it was served on the institution.
But it needed to be on him.
Yes, I would imagine it would have, just as in Silva. I just don't, I don't know the answer to that, Your Honor. What I would say is he didn't show any evidence to suggest that when he was confronted with the fact that they had taken the sneakers, he said, hey, I never gave anybody any permission to show my sneakers, or why did you guys go and do that? He didn't make any objection to it.
In what circumstances was he told this?
He was told in his second interview with Boston Police.
He was told in his second interview with the
Yes.
Okay.
He was confronted with the fact that blood that was, well, as the detective put it, the victim's blood was on his sneakers.
I'm sorry, the warrant wasn't served on Silva, on the defendant in Silva.
I believe it was served
given
on the
to him.
institution.
Well,
It
no,
got
but
to
it was,
him
it was,
eventually.
Yeah,
it was given to him. It was
Yeah,
given to him.
eventually. I would also point out in Silva, the sneakers in Silva that were considered contraband weren't disposed of. It was very clear in the opinion that they were either mailed back to the defendant's family or
But
to
that was
someone
the
else.
policy, yeah.
That was part of the policy,
Right.
yes. So at the end of the day, Your Honors, I would suggest to the court that Judge Healy got it right. The defendant didn't meet his burden of showing that he had an expectation of privacy.
I'm trying to think of whether or not, we have various case law regarding the handling of inventoried documents, which limit the ability to examine inventory documents in the absence of a warrant where it's investigative. Does this conform to that, or is this broader than that?
I would say it at least conforms with it, Your Honor, for the reason that there was no closely examining the sneakers. There's no evidence that the officers closely examined the sneakers. What they did, as I pointed out, Sergeant Fontaine testified, the sneakers were merely taken out of the bag, placed on the table, and the officers simply viewed the reddish stain on the tongue. So what they saw was really a plain view observation that would have been visible to anybody, including the MASSAC officials when they inventoried the sneakers at the outset. So I would say it at least conforms with the line of inventory cases, Your Honor. And again, as I point out in my brief, even if this observation was struck from the warrant, there was still sufficient facts in the warrant that would have supported its issuance for the sneakers in any event.
Yeah, well, and it does seem thin, doesn't it?
Well, I would say-
Without having blood on the sneaker? I mean, yes, he is a drug dealer. Yes, he was not drug dealer. He was a drug addict. He was trying to purchase Klonopin from her, and she's found dead, therefore probable cause to believe he was the killer?
It's a little bit more than that, Your Honor. It's that he is a drug addict. It's that he has a very contentious relationship with the victim. It's that on numerous prior occasions he had stolen material from her and robbed her. And it's that he had access to the apartment he was seen hanging around by his admission, he was seen hanging around the apartment a night or two before the murder. He had wished to purchase Klonopin pills from her, but he didn't have the money to do so. And it's the fact that the victim had injuries that were consistent with defensive wounds, and when the defendant is admitted to MASSAC, the officers saw on him injuries to his hands and his knees, which would suggest that perhaps she was fending off her attacker, and the defendant was the person with the motive, the opportunity, the know-how to get into the apartment to do so.
So the police saw on his hands
Injuries, Your Honor.
injuries.
Yes.
What did the search warrant seek? Was it only the sneakers or was it all the clothing?
Sneakers, clothing, and I believe it went even further to request issuance so that the items could be searched and swabbed for DNA testing.
Okay. So that's consistent with the spatter.
Precisely, Your Honor. Detective Bliss specifically avers, given the nature of the crime scene, there was blood everywhere. He said in his experience, someone who was either the responsible for or present during the homicide, it would have been very unlikely to escape that scene without having some blood on their clothing or sneakers.
And with regard to the Matai issue,
Yes, Your Honor.
different result if what the memorandum had said was 1 in 100 as opposed to 1 in quintillion?
It would probably be a different, I may not be making the same arguments that I'm making here. But at the end of the day, this court is looking for a substantial likelihood of miscarriage of justice. As I point out, the defendant concedes in his closing argument that the victim's blood were on the sneakers.
That was in the closing argument.
That's in closing argument.
But I think a defense counsel had a copy of this report.
Oh, absolutely, Your Honor. Absolutely. As I put in my brief, I put the notices of discovery in the appendix to my brief. I've also filed with this court a motion to enlarge the record, which my brother has not objected to,
Yeah.
which includes the report. And it's really, I mean, it's astronomical, the numbers here. So as Your Honor's pointed out, this evidence is incredibly damning. Had it come in, it would have made the Commonwealth's case even stronger. And this isn't a case where the jury just didn't have any benchmarks. They didn't have any way to assess the evidence here. They had heard about the cigarette butt. The numbers, the DNA testimony in the chart for the cigarette was very closely aligned with that for item 85, which was the stain on the bottom of the sneaker. That's at page 30 of the Commonwealth's appendix. The court can go back and look at the chart itself and see.
Was it clear it was the same alleles?
Yes, Your Honor, except but for one. But the jury was instructed by the criminalist what that meant in the overall understanding of DNA. So the jury would have been equipped to understand I would say, the relative significance of the blood evidence that was recovered from the sneakers. With respect to the other issues, I'm happy to answer any questions.
Could you address the voluntary intoxication instruction?
Absolutely, Your Honor.
Is there a difference between giving a voluntary intoxication instruction with respect to the premeditation, which goes to one thing, but something different for extreme atrocity or cruelty? Shouldn't it have been given as to the other, the extreme atrocity or cruelty?
I don't believe so, Your Honor, particularly where it wasn't requested and there was no evidence that he was intoxicated whatsoever. There simply was no evidence whatsoever that he was intoxicated at the time of the murder.
Okay.
Just none.
Okay, thank you.
Thank you very much, Your Honor.